Earlier this month, the National Association of Realtors published a report where there is a lawsuit where a buyer is suing not only her agent, but she's also suing the listing agent as well, alleging that professional negligence and constructive fraud against both of these agents.
Yeah, and this is something that I've said on video before, Melissa, that our attorney has said that the Real Estate Commission, at least here in Maryland and probably all over the country, is inundated with claims from buyers over the last several years buying a home. They have huge buyer remorse. And, in this case, and we wanted to bring it to you guys to let you know that these things are happening. And there is a responsibility of real estate professionals, but also of buyers when they're purchasing real estate. And, in this case, Melissa, and we'll dive in a little bit, but in this case specifically, the court actually sided with the brokers in this case. But that's not always the situation. There was a lawsuit recently where I think the buyer's agent received $170,000 judgment because of, the court finding wrongdoing with disclosures.
So let me just take a moment to read from the report. In the claim against the buyer's agent, the plaintiff alleged that the agent failed to disclose material information by not telling them about zoning limitations for a fence. For example, height and setback requirements. The plaintiff owned a service dog and wanted to adequately enclose their yard, but after closing, learned that zoning limitations prohibited the desired enclosure.
Yeah, and with regards to the claim against the seller's agent, the plaintiff argued that the agent committed professional negligence and constructive fraud by failing to disclose information about a significant past water intrusion, which caused extensive mold damage discovered by the buyer after closing. And this case was in Montana, and it goes on to say that in Montana, sellers' agents are required to disclose known and adverse material facts concerning the property. Now, guys, here's what I want to say about this case. In this situation, the buyer had a service pet, right? And it appears in reading the court document, which, we'll publish in a link below. It appears that this particular buyer wanted a specific sized fence, a specific height, and didn't want to, have the setbacks that kind of constrain the area that this buyer would be allowed to have their dog run freely within a contained fence. The issue is here, should the buyer's agent have kind of dug in a little bit deeper and said, what kind of fence? Obviously, I'm sure the buyer said to the agent, hey, look, I have a service pet. I need a fence in the backyard. Do you think that I could fence in the backyard? These are kind of like the typical conversations. A buyer's agent may say, what are you looking to do? Is it part of an HOA? Are there restrictions? You maybe just can't put up a fence. Despite the fact that the court sided with the buyer's agent in this case, does not relieve, in my opinion, the buyer's agent's responsibility to dig in a little bit deeper, find out what the buyer's looking to do. However, the reason why the court sided with the buyer is because the zoning is public information, and there wasn't anything specifically that required the agent to point out zoning facts that were public. So, it is the buyer's responsibility. Ultimately, they're the ones signing the contract. And, in the case, Melissa, with the seller's agent, this happens to be the seller's brother-in-law. So this is a family member. And, the buyer had an inspection, and I think this is the one thing that saved the seller's agent or the seller's broker, is because during the inspection, the inspector had pointed out that there was negative grades going towards the foundation and that it appeared that there had been prior water intrusion. And so apparently the buyer did ask for some things back, and apparently it was done, but it went on that the appraiser even said in his report, for the lender, that, hey, it looks like there's been water intrusion, and it quoted the listing agent, which he denied in court, stating that the listing agent said, well, in the last, 38 years, I think it was, that the sellers lived here, they've never had any water intrusion. Of course, the listing agent denies it, saying it, whether it was true or not, doesn't matter. But, here it is, guys, that as a real estate professional, every single day we come up against situations where a seller may or may not disclose certain things, and agents sometimes may or may not require the disclosure or, suggest it to the seller, hey, we should get this looked at or get it checked out. When I'm walking in a basement, I'm looking for it, right? If it looks like there's been prior water intrusion, I'm asking the seller, have you ever had a leak in your basement? You've been here 38 years. Has your basement ever leaked? If they say yes, then I need to dig into, well, what happened? How often? If they say no, and I can clearly see water lines, it's my responsibility to tell the buyer's agent when, disclosing or when talking about the property, hey, look, the seller said there's no water intrusion in the basement here, but I can see a water line. And I'm just telling you that because the buyer may need to check it out or may want to check it out, may want to have an inspector take a look.
You're 100% right, Todd. And the court case goes on to further discuss how after the buyer closed, she learned later that she could not erect a fence enclosing the yard due to setback requirements and height limitations for the corner lots. The zoning department allegedly informed her that only 10 feet of the perimeter could be fenced in and that the fence would have to be more than 22 feet back from the curb and only 4 feet high on the front side of the house. In addition, several months after the buyer took possession of the property, she discovered flooding in the basement after a rainstorm. The buyer removed the wood paneling in the basement and discovered mold. It was inspected, and based on the assessment of the mold and water damage, and the inspector in his deposition stated that the water infiltration into the basement had been going on for quite some time.
Yeah, and this is the kind of situation, guys. You say that sellers, Melissa, we want to believe in people, right? But there are a huge amount of sellers when it comes time to selling their home. They're like, I don't want to talk about that, or I don't want to disclose that. It is the buyer's agent and the seller's agent's responsibility to open your eyes and look around. Like I said, when you're the listing agent, you should be going in, asking a bunch of questions. It's not, I don't want to ask because I'm afraid of the answer. It's, I need to ask the question to protect my seller and also protect the buyer. Here in Maryland, even though we don't represent the buyers when we're representing the listing agent, that is illegal, right? A broker can, because there are two, different agents involved, a buyer's agent and a seller's agent. But unlike a lot of different states, Maryland does not allow for dual agency within a realtor. So a realtor cannot represent the buyer and the seller in the same transaction. However, if the agent, the realtor, is representing here in Maryland, representing the seller, they owe care to the buyer's side, even though they don't represent them. And care is described, right? Describe disclosures or material facts. A material fact is an agent's knowledge about a property that, if the buyer later found out, would either cause them physical harm, financial harm, things that are not disclosed that the agent has knowledge of or should have knowledge of, it could be found out. So guys, here's a classic case of what we say is caveat emptor, and that means buyer beware. And even though you're represented under a broker agency agreement, whether you're buying or selling, it is your ultimate responsibility to take the bull by the horns, guys, and find out information for yourself. In this case, what could we learn from a buyer that probably paid a lot of money for a house that they could only fence in 10 feet of, right? Because the setback, it wasn't the privacy fence that they were looking for. So what could that buyer done previously to buying this house? Well, they could have asked a lot more questions on, hey, I want to build a fence. What do I need to do that? Can I even have one? This is important to me. Do you want to build a pool? Do you want to cut down trees? Do you want to regrade your lawn? Do you want to change the color of your door? These are all things that could be prevented by HOAs, condominium documents, zoning ordinances. And then if you are the listing agent, what could have happened here? Obviously, for the brother-in-law, don't you want to protect your brother-in-law? Worked out this time, but guys, it may not in the future. Listing agents should be asking, looks like water intrusion in the house. Hey, I'm a real estate agent. I should know these things, right? I'm not saying that we should be experts in water intrusion, but we should be experts in seeing what it looks like as a result of water intrusion. The other thing is that buyer's agent should have walked around too and really identified it for themselves. So guys, we're just trying to keep you safe out there, trying to keep you educated and updated on what you should know when you're buying and selling a home. It doesn't always work out in your benefit if you're going to take your real estate agent to court. Sometimes it does, but guys, if you're an agent, let's stay out of the courtroom anyway. Thanks for your time, guys. And if you received good information here in this video, you can smash that thumbs up. It'll let Melissa and I know that you did. And as always, we appreciate you subscribing to our channel. Hit the alert bell. You'll know every time we upload content.
And you guys, please keep those comments and questions coming. We love reading them and we love responding to them.
And by the way, guys, there's never a better opportunity than this video right now to plug our new YouTube channel called Real Estate Agent. If you're serving the industry and you want to stay more informed, you can cruise on over. The link is in the bottom of our channel here. Take you over there. You can subscribe to that. We are packing content, getting ready to bring it to you. This is all about real estate agents and anybody serving the industry. See you next time.
See you next time.
Sachs Realty, Maryland broker number 607720, office number 443-318-4514, equal housing opportunity.